Hi, and welcome to my show, Justice Matters. My name is Patricia Corrales. Many of you know me as Patty Corrales, and as I've mentioned previously, I used to work as an ICE senior attorney for Immigration Customs Enforcement for almost 18 years. I'm now in private practice, and today on my show, we're going to discuss some immigration updates on certain issues that will impact the immigrant community. And generally speaking, I always have someone on my show, either an attorney or another guest. But today I just wanted to focus on certain updates that will affect many of the immigrant community. So let me begin by talking about the big issue that most people who come to me ask, and that is the driver's license law, AB 60. When will that come into effect? Well, the driver's license bill and the driver's license law will come into effect January 1st, 2015. You can start calling into DMV to get your appointment to set up your appointment for a driver's license test as early as about 15 days in December, 15 days before January 1st. So don't start calling now. The other thing that I really want to talk about in regards to that is this. There are many consultants out there and notarios who are already charging people money for forms to fill out for the driver's license initiative so that they can get their driver's license in January. I want to make sure the public understands these forms are free, absolutely free. You should not be paying anyone to fill out these forms. They're very self-explanatory, so you can do this on your own. Just go to the DMV website and you will be able to download those forms when they're made available. So please do not go to any notary or immigration consultant and pay anyone to fill out forms on your behalf for this new driver's license bill. So that's very important, and I want to make sure that gets out. Secondly, in regards to the driver's license bill, what I want to say is you will get this driver's license. Your driver's license will look different than a regular California driver's license. You cannot use the driver's license that you get for the purpose of travel. So if you want to travel to an outside state, you cannot use the driver's license as a form of identification for travel purposes, nor can you use the driver's license as a form of identification to obtain a job. You cannot use the driver's license that you will get from the state of California for any other purpose other than to drive on the roads of California. And even if that's the case, what a great thing for many of the immigrant population. The ability to drive on the roads of California with authorization of the state of California will not only hopefully create safer drivers, but it will prevent many of the immigrant community from obtaining tickets for not having driver's license. And for many, it's a way of getting to their jobs or getting to school. And this is a great opportunity that the state of California is affording many people in the immigrant community. So please take advantage of it. Remember, the driver's license bill becomes effective January 1st, 2015. All right, the next next update that I want to talk about is DACA, Deferred Action for Childhood Arrivals. We are now in the process of DACA renewals. What does that mean? That means that those who had deferred action for a period of 2 years, you got to look on your card to see when it expires, because you have to reapply 4 months prior to the expiration on the date of that card. Now, you can't apply before, and you certainly should not apply later. There are ramifications, legal ramifications, if you fail to apply within the period of time permitted and beyond the expiration date of your current employment authorization card. So be very cognizant, if you have children who have deferred action status, that they must apply 4 months prior to the expiration of the card. Now, do you need a lawyer to reapply? No, you don't need a lawyer to reapply. Do you need to go to an immigration consultant or notary? No, you don't. The form to reapply for deferred action for childhood arrivals is very self-explanatory. There are some questions that have legal significance and do require the assistance of a licensed attorney, and I would recommend going to a licensed attorney for that purpose. Is it automatic? yes, it should be automatic with a couple of exceptions, and that is, since the time you were granted deferred action status, if you have been convicted of a crime, that crime may impact your ability to renew your deferred action status. So that is significant. Also, if you left the United States for a period of time and you left without permission, that will impact your ability to renew your deferred action status. So there are some situations where reapplying for your deferred action status, your DACA, will not result in an automatic renewal of your DACA. So be very cognizant of those exceptions, if you will. But to reapply for deferred action status, you have to submit the new I-821D form to USCIS. You have to submit it within 4 months of the expiration of your current EAD card, your employment authorization card, and you have to submit proof that you were granted DACA previously, so a copy of your deferred action card, your driver's license, and your Social Security. That's really all you need, except if you have been convicted since the time you were granted DACA to the time or period you're applying for renewal, you'll have to submit all the documents related to those convictions. Some convictions will knock you out automatically. For example, a client of mine came to talk to me about renewal of his deferred action status, and unfortunately, he was convicted of a DUI. Now, he had gone and allowed the public defenders he had gone to criminal court, and the public defender, try as he might, wasn't able to convince the district attorney's office to knock down the DUI, first-time DUI, to a wet and reckless, which has some significance because it a wet and reckless conviction may or may not bar you from deferred action status. Now, in that case, my client would not be able to renew his deferred action status because a DUI is a basis to deny deferred action. So those are the things that you're going to have to look at when renewing your deferred action status, and for these reasons, it might be best to talk or speak with or have a licensed attorney handle your deferred action renewal application. So that's what's going on with deferred action. Now, many people say, well, I'm renewing, but can I renew again? We don't know what's going to happen. We have no idea if deferred action for childhood arrivals will continue after the president has left office. Remember, deferred action for consideration of childhood arrivals was an initiative, an executive decision by the President of the United States. It wasn't a law that was passed by Congress, so it doesn't have the protections of a law. So should the president leave and the next president come in and no longer want to renew deferred actions applications, that can happen, and that is a possibility. But those who already are in the process, I think, would be okay. Again, I cannot comment what will happen when the president leaves. We hope that the politicians who come on board understand the importance that deferred action has had for many of our young youth in this country. It has opened doors for them. It has opened dreams. It has opened possibilities for them. And I hope that they will continue with the deferred action program. So USCIS is currently taking within 2 months to 3 months, a very short period of time, to process the renewal applications. All right, talking about politics, I want to talk to the immigrant population about citizenship. For those that I have helped become U.S. citizens, what a great privilege. What an enormous privilege that this country has given you to become U.S. citizens, to be part of the plurality here, to be able to vote for those who you want to vote for the issues that are important to you. So I'm actually sending out this message to everyone who just recently became a U.S. citizen. This is the time, this is an opportunity for you for the coming elections to vote. Go out and vote and make sure that your voice is heard, because you have a voice. I don't care if you're from Guatemala or you're from Colombia or you're from India or from whatever part of the world you're from. You have a right for your voice to be heard. That is what this country is built on. It's built on freedom of speech, freedom of association. It's built on many, many freedoms. It's a democratic country. So you have a right to have your voice heard. Now that you've been granted this wonderful privilege of becoming a U.S. citizen, don't just sit back and let others speak for you. Speak yourself and let your voice be heard. So go out to the polls and vote. Now, going on to another topic, another update that I want to talk about. I've had a lot of clients come to my office and ask me about this new law. Abogada, attorney, I've heard of this new law that after 10 years I can apply for my work permit, and I want to apply for that. I don't know where that information is coming from, but there is no new law just based on your years of residence in the United States. There's something called cancellation of removal. It's a form of relief, meaning a form of being able to stay in the United States lawfully and legally as a permanent resident. But it's a form of relief, a way to obtain this residence only if you are in deportation proceedings, only if you are in proceedings to be deported. So in defense of that proceeding to be deported, you apply for this type of relief because you have 10 years of residence in the United States, you have either a U.S. citizen spouse or child or parent, or you have a lawful permanent resident, citizen, child, or parent. And you are a person of good moral character, meaning that you have no crimes that would bar you from being eligible for this relief. So if you're not in deportation proceedings, if you're not before the immigration courts where the ICE or the government is seeking to deport you, you cannot apply for this relief. This relief is not something that you can apply for. You cannot apply for it to get a work permit. Now, if you are in deportation proceedings and you meet the criteria for this type of relief, you can apply for it, and this type of relief allows you to obtain your work authorization. Obtaining your work authorization is really important because it authorizes you to work legally in the United States, and as such, you can obtain a Social Security number that is a valid Social Security number for work purposes only. So there is no new law out there, okay? There is absolutely no new law. There is a law that has been in existence for a long time. However, you can't apply for this type of relief unless you're in deportation proceedings. So please, don't let anyone apply for you, because if you do, you could subject yourself to being not only having that application be denied, but then now you're going to find yourself in deportation proceedings. So before you weren't, and if you apply when you're not, you might find yourself in deportation proceedings. So lots of consequences to this, to applying for cancellation of removal. Make sure you speak with a licensed attorney in the state of California, or a licensed attorney who can practice immigration law here. And there's many, many good ones out there. So many wonderful attorneys out there that can assist you. One last update that I want to talk about. The I-601 waivers. That is the waiver for your unlawful presence. That's when you're married to a U.S. citizen spouse and you enter the United States either unlawfully without documents or you're not 245I protected. You can now apply for the provisional waiver here in the United States. It's called the I-601A unlawful presence waiver. What we're noticing is that USCIS is sending out what's called requests for further evidence. And these requests for further evidence are boilerplate requests, meaning that they really didn't look at your application. They didn't really look at what you submitted to show the extreme hardship that your U.S. citizen spouse or parent would face if you are not granted this waiver. Your attorney may have worked on it long and hard and have developed a great argument, but guess what? USCIS, I think because the amount of applications they're receiving are not really, their officers are not really looking at these applications and are sending back these requests for further evidence. And if you look at the requests, they're not specific. It's very boilerplate. It's like, send me everything in the kitchen sink, which tells me they didn't even take the time to review the application that was submitted and the evidence submitted on behalf of you and your spouse by your attorney that establishes that your U.S. citizen spouse or parent would suffer extreme hardship. That's very disappointing. Very disappointing. The only thing I can say is this: respond to those requests for evidence. You need to respond. You cannot disregard those requests for evidence and think, well, they already have my information. Why am I resubmitting it? Even if you resubmit the same thing, you need to respond to those requests for evidence, because if you don't, then your case would be denied automatically. So please don't ignore those RFEs, what we call RFEs, even if they look boilerplate. There is so much more to update you on, but I think for now I have said enough. If you have any further information or require any additional information on any of these issues that we touched upon today, please feel free to contact my office. You can reach me at Patricia.m.Corrales@gmail.com, or you can contact me at my office at area code 626-791-1434. Thank you, and have a wonderful, wonderful day.